Matt O'Connor from the O'Connor Law Firm here in Kansas City, here to talk to you today about what to expect when entering a plea and a felony plea. Well, first of all, the judge has to be satisfied that there's a factual basis for a plea. For example, if you're charged with drug possession, you must make a factual basis. And what a factual basis means is that on or about the date that the crime is charged, that you knowingly possessed a substance, to wit, cocaine or mushrooms, marijuana, etc., and that occurred in the county, that you did so knowingly, and that you are in fact guilty. They want to review with you your rights. What are the rights they're going to go over? Well, first we're going to make sure that you're the person that you say they are. We're going to ask you your name, whether you graduated high school, your highest level of education, whether you read and write in the English language, which is important because if you don't, there are certain things your lawyer should have probably explained to you beforehand and made sure that you understood. They will also ask you if you know what rights you're giving up. And what rights are you giving up? Well, when you enter a plea of guilty, you're giving up a lot of rights. That would include the right to confront and cross-examine witnesses. That's a Sixth Amendment right. The right to have evidence suppressed, and if that evidence is not suppressed, the right to appeal that suppression. Let's say you lose your motion to suppress at the circuit court level, and then you can take it up on appeal if you don't plead guilty. But if you plead guilty, that's gone. You can't appeal it. What other rights are you giving up? Well, the most obvious one, your right to remain silent. No one can make you testify. You do not have to testify. There is a presumption of innocence, and your failure to testify is an instruction that the jury would get that they can't factor that in to their decision. And in addition to giving up your right to have a jury decide whether the state can prove you guilty of each and every element beyond a reasonable doubt, you're also giving up the right to have the jury assess punishment if you're a first-time offender. In Missouri, we have what's called a bifurcated trial. The first part of the trial is to determine guilt or innocence, and the second part is, if you are found guilty, to have the jury assess punishment. So, again, you're giving up your right to remain silent. You're giving a right to confront all witnesses that the state has, to all the evidence that they have, and to cross-examine that and to challenge it, to call witnesses on your behalf, to testify if you want to testify, and you don't have to testify. You're giving up your right to remain silent by admitting that you've in fact committed the crime. And again, you're giving up the right to have the jury assess punishment. So those are all factors to consider. The judge will also review with you that in addition to the factual basis, that you understand the range of punishment. And depending on the type of case, it is A, B, C, D, or E felony, the range of punishment therein. And they'll make sure that you are not under the influence of any drugs or alcohol or under the care of a psychiatrist, and that you understand the proceedings and what's going on. Pretty good reason for that. And then finally, they'll ask you if you have any complaints about your lawyer. Is there anything that your lawyer didn't do that you wanted them to do? Or is there anything your lawyer did that you did not want them to do? And the whole purpose of that is to make sure that you knowingly and intelligently waive your right to a trial, waive your right to remain silent, waive your right to see and confront the evidence against you. And in that way, the judge makes sure that your constitutional rights are protected in that plea process. Some judges will automatically order what's called an SAR. It used to be a PSI, which was pre-sentence investigation. Now it's called a sentencing advisory report. And what that is, it's a report that gives the judge a background, and you meet with the probation parole officer who drafts the report. They'll get your school records, whether you graduated, and they'll also run your salient factor, your risk for reoffense, and the general range of punishment according to the Missouri guidelines, which are advisory. 99% of the time that can be positive unless you have a long list of prior convictions, and then it's not so positive. So in most cases, the judges will order with the SAR. In some cases, they will proceed right to sentencing. But that's not always the case. That's judge to judge. It's something you want to talk to your lawyer about definitely beforehand. So that's what you're giving up, and that's what the process is. And remember, you are under oath. So when you tell the judge the answer to these questions as part of the plea, make sure you're telling the truth, because otherwise you're committing perjury. And always remember, if you're not sure of something, you can ask the judge for a moment to talk to your lawyer, who will be right there with you through that process. I'm Matt O'Connor from the O'Connor Law Firm. Thanks for listening. Choice of a lawyer is an important one and should not be based on advertising alone.